So yes, thank you very much, Ran, for joining us today in this direct seminar. For those of you that don't know, I see that there are people that have joined today, I think because they know Ran more than they know direct. So direct is this center that we have here in Denmark, where all the computer science departments from all over Denmark are collaborating in this ambitious project. And we had a series of these direct talks, and today we have Ran Canetti with us. I'm very happy that Ran is with us today. Ran is currently is a professor at Boston University. Before was in Tel Aviv and I think at IBM and many other places. He's very well recognized for his work. He is an ICR fellow, an ICM fellow. He has received the RSA award for mathematics. And even if you don't know it, you're probably using Ran's work right now. Ran has established some of the foundation of both theoretical and practical cryptography. Just an example, the HMAC MAC authentication scheme is probably being used right now to authenticate the connection we are having this talk on. And then I think that every PhD student on the planet respects and fears the name of Ran Canetti because of the universal composability security framework, which is what has become the standard for proving security of cryptographic protocols. And it's it's more of an encyclopedia than a paper. If anyone has ever tried to read it, they know what I'm talking about. But enough with the pleasantries. I think now it's time to hear what Ran has to tell us about. And today is going to talk about can cryptographic algorithms affect legal doctrines. So thank you, Ran, so much.
Thank you. Thanks for the introduction. But anyway, yeah, so the last let me say that I started doing cryptography many years ago as a student just because it was fun and fun playing games with algorithms and proofs and stuff and with nice mathematics. And we always wrote in the introductions, social justifications for the protocol, but it was clear it was just a game. But as time went on, it was became more acutely visible, inescapable that actually this is truth, and society needs us, it needs cryptography, and it maybe uses cryptography if it doesn't need. And there is a reason to try to understand exactly the uses of cryptography and algorithms in general in society, in the legal system. And in the last several years, I've been spending quite a bit of time on studying this. And this work is, but I'm going to talk about things that I've, worked on in that respect. Okay, so let's start. Okay, so yeah, so this is based on work with Shafi Goldwasser, who is a cryptographer, one of the parents of the field, and Rebecca Wexler, Evan Zimmerman, and Ken Bamberger, who are law professors, and Dorbitan, who is also cryptographer, postdoc at Berkeley. Okay. So we all know, in society, we pay in order to benefit from society, and the way it's done, it's this concept that I think we all learned in philosophy or political science, the social contract. The different philosophers who put up different types of forms of contract, or the way to think about the social contract, the Hobbes, Locke, Rousseau, etc. So okay, as we said, living in society benefits us in great ways, but it involves compromises, as we all know. So lots of different types of compromises. The liberty of one versus the liberty of another. Liberty of one versus physical harm for another. Physical harm of one versus just plain well-being of another. Etc. It also not just individuals, just groups. Having one group or versus harming another group, and we all somehow have to make ends meet and learn to live together. And we know that no set of decisions, rules can be complete, so universally accepted by everybody. Kind of the nature of things, and we have to accept that. And because we have, different preferences, religions, philosophies, emotions. There's no way to agree on something, have something that everybody agrees on, and so what we have instead, we have engineered a legal system that allows to resolve a dispute and allow us to coexist together as society in the long run. And how the legal system works, and it really is crucial for everybody, right? For the well-being of society. And the point of the social contract, what you give and what you take from society is of course evolving, and evolving, with the makeups of society, with the technology changes, right? And as we have new technologies, we have new harms, new dangers, new opportunities, new power relations, etc., and also new solutions to conflict become available. And the point is that it's not always for the better, because sometimes technology can actually make things worse. As we know, just looking at the history of humanity, there's lots of examples. No need to go to spend time on this. But before, what you need is a legal system that is nimble enough and versatile enough to accommodate this evolving contract, right? And this is what we're trying to do, and it's always a struggle. So in particular, pertaining to us, computer science, and these times, there's the question, of course, the elephant in the room, the social, what's the social contract for data, and in particular, data sharing. The statement that data is in the oil, right? Maybe I can modify it a bit. It's not in the oil, actually, it's in the oxygen, maybe, because first, it affects everybody. Data about anyone affects everyone. It's just out there, and we can't really live without it even for a minute. And it's not localized, and also it's not additive, as we know. We have having twice the amount of data is not twice the value. Sometimes it's just the same value. Sometimes it's infinitely more value. And data can combine, disappear, appear, all these mysterious ways. If you're an algorithm person, definitely a cryptographer, I don't need to explain that. It's clear. But for people who are not computer scientists, this is sometimes, it seems surprising, especially for legal folks. But they need to understand, the different perspectives. And data, of course, can create new harms and benefits for different people, different groups of people. And so there's the issue of privacy. That everybody's talking about privacy, but maybe privacy is just privacy in the computer science sense of hiding information or re-identification is only maybe the tip of the iceberg of what data can do. There is the issue of control and how data affects, even without the identification. My data can affect me or affect others in many ways, and definitely the data of all of us together. So issue of personality instead of my feeling of myself and my ability to thrive within my world without being controlled from the outside, and etc. So all of these issues are affected by data, and also there's of course the new benefits and the new distribution of wealth, new money can be made from data, and also creates new power structures, control structures, dependencies, etc. So learning to deal with that and how to update the social contract to accommodate the use of data, and of course sharing data among that is owned or stored or held by different people is of course a big thing. And so we have this big theory of secure computation, secure multi-party computation that allows us the technology of sharing data and putting it together to compute some functions. Of course, this technology only enhances the need for a new social contract or legal system or way to think about how to share data in such a way. So this is one clear aspect, but somehow this is, I'm just putting it out there, but this is not the focus of my talk. I want to talk about a different type of harm to social contract that relates to data. And this is more in some sense, so it's not about pulling together data that is held by different people, but talking about the harms for data, for disclosure of data within data which is completely proprietary and owned maybe by one person or one group in the process, in the legal process itself. So what am I talking about? So we know that resolving legal disputes in general is costly, to both the litigating side, to society in general, to the legal system, of course, and the legal system is aware of that, and of the fact that balancing the cost is really crucial for a workable legal system in a society, right? So and we have tools to deal with that. Or have developed over the years to deal with that. So the idea is to balance the cost for the litigating sides and obviously the cost for the system itself. And sometimes you need to balance. It's kind of like not maybe ideally you would not want to, but sometimes you are faced with this choice, and we'll get to this in a few minutes. Is the need to balance even the truth finding itself process, right, which is the core of the legal process, just to find the truth, and the cost, because they maybe just finding the truth would be too costly to one of the sides, and what do we do with that? So, but the legal system has acknowledges that and have ways to deal with that, but traditionally, this had to do with physical issues, and the question, what about disclosure costs or disclosure harms for data, right? Given this very different aspect of data. So it's not always, commensurate and measurable in ways, what exactly is the harm in disclosing data, and can harm not just the litigating parties, can harm third parties, and the harm to the litigating party itself can be non-commensurate, etc. So this is one thing that we need to address and think about. And another question is, it's really inevitable. Do we really is data disclosure in inevitable consequence of litigation? So we'll talk about that. So with that in mind, so let me just jump into an example and actually give you kind of several examples, and then we kind of go on from there. So let me talk. Let me give you a story. Tell a story that it's a true story. But all of the stories that I'm going to talk about is from the U.S. legal system, and I know that in Europe it's different, but I hope there are enough commonalities for this to be relevant. So there was the case of U.S. Versus Budziak. So we know that some people use the internet to do illegal things. And in particular, maybe surprised, but it is the case. And one of the illegal things that people do is share illegal pictures, in particular child sexual abuse material, CSAM, child porn pictures online. And this is, of course, illegal in the U.S. It's completely illegal to hold any such picture, no matter what, unless you are law enforcement dealing with that. But people still do it. And the way that the law enforcement of the FBI is sketching those criminals is trying to tap on the distribution mechanism that those people use in order to obtain evidence and then put the speaker to trial. And this is, of course, a very important task. So the pictures themselves are not just pictures. There were child that were abused to create those pictures, and the more there is consumption and there's demand and there is money in the system, the more children are being abused, and of course there is a clear legal, clear social value in stopping that and catching the criminals. So what the FBI is doing is creating those tools or hacking tools that actually they hack existing systems, and they fool suspects into believing that they are interacting with the actual system, whereas in fact they're interacting with law enforcement. And this way, law enforcement can find the evidence and put them to court. So, in particular, in this particular case, the FBI used some modified version of the LimeWire peer-to-peer file sharing. In order to trick the client's computer to send all the little shard, all the different shard of certain child porn files to FBI computers, and FBI this way could prove that that particular, or could have an evidence that that particular person disseminated child sexual abuse material. So then the person was tried, and in the court, in fact, before the trial begins, the U.S. system, there is this process of evidence collection, and this is before the jury or the trial begins. They just, the two sides bring in, or in this case, the prosecution bringing up the evidence, and then the defendant lawyer is checking the evidence and saying, is this evidence okay or not? And once this process ends, now the evidence, now the trial begins. And this particular process of figuring out the evidence is, in most criminal cases, is the crucial part. I mean, the trial that happens later is of course important too, but the evidence is crucial, especially in such cases, right? So the defendant, stated that no way could this happen. Even though system was found in a search in their computer, the defendant said that they never actually shared this, and they actually set their computer for only for local sharing, for local viewing, and this did not enable sharing. And of course, this is a big difference because holding system is one, there is one punishment for that, and distributing system is a much bigger punishment. I think it's 4 years maximum versus 20 years maximum in jail. It's a big difference. Anyway, and then the defendant said, okay, I don't trust this software that was used by law enforcement to incriminate me, and I want to see it, and I want to inspect it, and I want to see that it's okay. And actually, the defendant brought several, not just a general claim, but several very focused, pertinent arguments and claims why why this could be mistaken. Right? So never mind the details. I'm happy to go into details here, but the point is there was a legitimate claim to a plausible argument that this particular software could have been mistaken. So on the other hand, the prosecution said, look, we cannot show the software to the defendant, or the defendant lawyer, the defendant expert, because once we do that, this will become known, and the efficacy of the software will be gone, and we will not be able to use the software to find future criminals, which is a very legitimate concern, of course. As as we said, we want to stop child abuse. So then what do you do? So there is actually a legal doctrine in the U.S. talks about law enforcement privilege and when it should or should not expose its hidden investigative tools. And this doctrine actually balances the harms to the defendant versus the harms to the system. And which kind of like strange for the harm, it could be on the one hand, the defendant needs to have a fair trial, and there's this due process of a trial just to find the truth. And on the other hand, there's the efficacy of the system. So in this particular case, the judge was convinced by law enforcement and accepted the evidence without disclosing the tool. And there was a trial, and the defendant was found guilty, went to jail. At the same time, there was actually an appeal for this decision, and in a couple of years later, an appellate court reviewed the process, did the case, and actually reversed the decision of the lower court, and asked, or the way it goes, he just remanded it, sent it back to the lower court, and said you should actually ask law enforcement to see to disclose their files. And here's from this particular judgment, here's things that they cited. So just let me read it very quickly. So a party seeking to impeach the reliability of computer evidence should have sufficient opportunity to ascertain this by pre-trial discovery whether both the machine and those who supplied the data have informed their task, have performed their task accurately, right? And even further, it is quite incomprehensible that the prosecution should tender a witness to state results of the computer's operation without having the program available for defense, scrutiny, etc. Which maybe is for computer scientists it's obvious, but apparently to this judge it was obvious too, but it's not so obvious in the system overall. So anyway, so the court told the FBI, asked the FBI to disclose the evidence in this particular case. And actually, in that case, it's a funny thing that the FBI said that we were unable to locate the software. It was gone. It was a vendor, no longer there. Sorry, we cannot find it. And of course, the case was dismissed, and the defendant released from jail. So we kind of like it's a complete failure of the system, right? So we don't even know whether the person was guilty or not. It could be that the person is guilty and still went back to society and can do harm to gain, or it could be maybe the person was not. The system failed. So this is one example where they talk about harm of disclosing information versus harm of not proving. So there are other cases in the legal system that are like that, maybe less extreme as this criminal justice example, but still very pertinent, right? So here's another. Here's another story. So there was a company that was approached by some potential buyer to. But it was a representative of another company that presumably wanted to buy it, and they asked for some proprietary information about the company just to see if it was towards buying proprietary software data, and the data was actually the most important information. It was lobbying company, and there was lobbying information. And then after they saw the data, it turned out the deal fell through, and actually it turned out this front was for another company that's actually a competitor that took the data and used it against the press company itself. At least that's the claim. And the issue is now under litigation. So the thing happened in 2018, and it's still under litigation. But again, there's this issue that somebody wants to come and maybe value or get your product. and he wants to see your data, and it's private, but you have to show it in order to prove to them that you're worthwhile. But then once you show them, what do you do? So in another story, 1985, the Coca-Cola bottling company, which is a different company than Coca-Cola company, they sued Coca-Cola company for charging too much money for the Diet Coke syrup that they sold them, where the bottling company was supposed to, mix it with water, put it in water, right? And they had an agreement for Coke, Coca-Cola came with Diet Coke, and Coca-Cola said the Diet Coke is not under the same agreement for Coke, and they charge more money. And the bottling company said no, and it actually should be. And then they went to court and back and forth, back and forth. At some point, the court got convinced that Coca-Cola company should disclose to the bottling company the secret recipes for Diet Coke and Coke, so that they can decide whether the agreement from Coke pertains to Diet Coke too. But of course, the Coca-Cola company did not want to do that. So it's rather, it settled for in very unfavorable terms rather than disclosing the formula, right? Again, either you disclose or you lose, right? So the common theme, those and there are several many others, is that there's the common wisdom that comes again and again and again that to prove a point, you need to disclose relevant, pertinent information, and to better convince, you need to disclose more information. And however, disclose more information, exposes the disclosure to extraneous harms. But the point is that it is what it is. It's not tough life, but there's nothing to do about it, right? So in particular, trade-off is inherent. So in economics, there's another name for it, Arrow's disclosure paradox, the boundaries of the firm. That's what they use in order to justify trade secrets and IP rights, because once you disclose something, it loses its value because everybody knows it, and now it's no longer valuable. So essentially, this is the basis of the Arrow's paradox. And in the law is, again, what you said is that the only thing that you can do about those situations is to find the right balance between the harm of disclosing data and the harm of not being able to convince, right? So for the cryptographers in the room, it's clear that we want to challenge that wisdom, and the fact that with the right technology, we can actually regain trust in the system. I mean, actually be able to prove things with only minimal exposure of sensitive information. And furthermore, once we adopt this technology, sorry, second, sorry. What did I do? Press the wrong thing. Yeah, okay. Sorry. So once we adopt this technology, we also have a much bigger, richer, whatever you can say, fine-grained solution space of different potential solutions. It's not just either disclosed or not disclosed. There's a whole range of possibilities in between of, we can disclose some, partial amount of the data, some function of the data, some yes and some no. And this gives a much richer space to find compromise that fits everybody, and allows for new legal thought again about how to think about data disclosure and harm. And this is kind of more like what I said earlier about multi-party computation, but it's a similar point. And the main tool that we would use is this concept of zero knowledge proofs. And so let me tell you about it. So I think probably half the audience at least knows this, but never mind. I always was told, never underestimate underestimate the pleasure you give people by telling them something they already know. So let's do that. So let me try to give an example to demonstrate the concept of zero knowledge proofs via an example. So example is adapted from a book of Ronnie for something else, but the beautiful proofs. But never mind. So assume that we have the mathematician working with the friends in the woods, and the mathematician's friend says at some point, I have this amazing ability. I take one look at a tree and I know exactly how many leaves it is. I have this new glasses. I know. So, and the mathematician, skeptic, would say, sure. So how can the mathematician verify that this is really true, such a claim, So here's a way for the mathematician to verify such an outrageous claim, right? How can the mathematician verify that really the friend really knows how to count leaves on trees, right? So what can the mathematician do? Says, okay, really, you cannot guess how many leaves are there on that tree over there. So the friend would say, 145,679. Great. Okay, sure. So how do we know it's correct? So what the mathematician, here's something the mathematician can do: can go and pick up secretly some random number of leaves from the tree without the friend seeing. And particularly, at this point, it shows, look, counted, 29 leaves, and you can say, okay, so how many leaves are there on the tree now? So now the mathematician can look again, and maybe she said, maybe now there's 145,650, and then the mathematician can of course compare and check and check and see that this is right. So you can actually subtract see one number from the other and see if it matches the leaf in their hand. So if you do it several times, then maybe actually the friend actually can do those things, right? So this is a nice way of how to have somebody prove things to you, even that you can actually verify efficiently, even though you cannot do it yourself. But how do we make this interaction with your knowledge? In particular, how now you are thinking you are the friend who knows how to count leaves on trees, but you don't want to disclose to actually tell the number of leaves on any tree to your friend, but you still want to convince them that you can do it, right? So how can you do it? Okay, so now let's do the story again. Yeah, I can count leaves on trees, and the mathematician said, yeah. So how many leaves are there on that tree? I don't want to tell you, but I can do something else. If you pick some number of leaves which I don't see, I can tell you how many leaves you pick, right? So then in their heart, the friend can actually count the number of leaves of that particular tree, keep it secret, and then the friend again picks some number of leaves, and then I said, okay, so now the friend asks, how many leaves did I pick? Then if a question. But the math is the same, and the friend can actually tell you, oh, you picked 29 leaves, but the mathematician can do the subtraction in the friend in her head, and the mathematician can now be convinced in just the same way. But the point is that now the mathematician did not learn anything from the process at all, except for the very fact that the friend can count leaves on trees on that particular tree, right? And the point is, how do we argue this? Whatever the mathematician learned, or the verifier learned here, is something that they could also already do by themselves without even talking to the friend. All they learned is the number of leaves in their hands that they picked, and it's something they can do on their own, right? So they didn't really learn anything. And this is the core of the concept of zero-knowledge proof. You can actually convince somebody in the truth of a statement or an ability without giving them any additional information, right? So again, contradicting this common wisdom that we described before about about proofs and legal proofs. By the way, Glad, how much time do I have left? I don't want to go over time.
I think so. So Malina said you had was like 30 minutes plus 10 minutes question, and I think if that was our schedule, we are running late.
I see.
I guess. I mean, if we finish at 4 p.m., I think it's fine.
Oh, I see. So yeah, okay. I want to. Yes. Okay. So I'll okay. Good. So I'll take maybe 10 more minutes. Okay. So okay. So we have this idea, and now can we apply it to digital information? So the fact is that we can, and this is the beauty and the power of this idea. So if you think about it, general truth of digital information. So how do we think about it? So now we have some public data D and some associated secret data, which we call S, and the verifier will have the public data, and the verifier wants to verify that the prover has some secret data S that works well, or that stand in some specific relation with the public data. And this specific relation, let's call it C. There is some check relation or algorithm C that's supposed to hold. And this is what we want to check. Okay, so here's some examples just to see what this means. So one thing is to say, say factoring, which is a hard problem. So let's say that the public data is a number, and the secret data is some 2 primes P and Q, and the C just checks that P times Q equals D. So now everybody knows some D, and the proves that they know 2 primes that the product is D, which is the basis for many crypto systems. So this is one way of thinking about it. Another thing that comes, that happens often is that, say D, the public data is the encryption, a ciphertext, and the secret data is a key, an encryption key, and a message M, and the plaintext M. And the statement will be that if you take D and you apply the decryption algorithm with the secret decryption key that I have, you'll get a message M, and message M has some properties. For instance, it has no mention of bad words, incitation, or incitement, or whatever other thing that you want to check. Or maybe it does have mention of something. So you can prove things about encrypted data without revealing the encrypted data or revealing the decryption key, right? So this is very useful. Another just example, so maybe the public data is D, which is supposed to be the hash of the secret data, and some threshold value V, and then the check just checks that really that given the secret data, when you hash it, you get the public information D, and also you check that the secret data has a value that is greater than V. So this is something, there is a public value V, and I want to show that my secret data is bigger than V. So this is a way to show it without disclosing, anything else. So just think of this check data is something which is like a conceptual thing, not something that you actually maybe run in the system, but this is a way to think about a specification of what it is that you want from a system. So as you see, this is a very powerful tool, and then a zero knowledge proof system is a pair of programs or a protocol between 2 parties, the prover and the verifier. That the verifier has the public data and the check algorithm that we want to check, what we want to check about the private and the secret information, and the prover has the same thing plus the secret information that only the prover has. And then they talk to each other many messages, maybe sometimes it's only one message, sometimes a longer interaction, but depending on the protocol. but in the end, the verifier, outputs yes or no, 0 or 1, accept or reject. And we know that, if really the prover has the secret data which satisfies things, and everybody's doing what it's supposed to do, then the verifier will accept. And if the soundness means that if the verifier accepted, then it means that the prover has some secret data that satisfies the relation, right? So, so very strong soundness guarantee, no matter what the prover is trying to do. The verifier said as long as they are running, saying what their algorithm tells them to do, then no matter what the prover is trying to do, they are guaranteed that if they accept, then the prover actually has access to this secret data. And then there's the zero knowledge guarantee that guarantees to the prover that if they do what they're supposed to do, the verifier will learn this one bit of information, whether I have the secret data as claimed, but nothing else. In this way of what we had before of counting leaves, right? The verifier could, all the other information the verifier could have generated themselves, they learn nothing from it. So there's the mathematical definition, but never mind. This is the concept. It's a very strong concept, and the state of the art in one word is that you can actually do it for any function, for any check, for any data, for any check program. It can be done in principle. And for over many years, with a lot of work to make it more efficient, more doable, more understandable, and today we have ways to do this relatively efficiently for a large set of check algorithms, and it's a fact that actually even used in practice in various systems, cryptocurrencies, anonymous credentials, etc. So this is something that this is real. This is not airware. So how can we use it to solve such dilemmas and change the legal system? So the one-liner is for cryptographers is have them prove the statement in zero knowledge. Them meaning the whoever wants to prove, right? But of course not so fast, and there are lots of challenges here. So one have to have a legal system that is based that is open to this. System, so one to understand legal audience and the general audience, etc. Because the whole point of a legal system that is acceptable and understandable by everyone. So one is to make this idea understandable, and of course there are a lot of loose ends and one is to tie down. So what is the public input? What is the witness? What So there's a lot of technical issues that need to be resolved in order to make the thing work. And already the way I described it, zero knowledge problem is, people can probably realize it's not exactly the normal way that we think about it. Something which is more tailored to the legal setting. And one of the things the question that keeps coming up is how to connect the digital information to the real world, to the ground truth. There's those proofs about numbers, how we connect them to the real world. So all these things we have to resolve in a case by case basis, and we need to kind of more than that find a theory or that talks about those things. Anyways, so there's a lot to do, and how would you actually how do you jumpstart it? How you would get it into the legal system? Who would have the incentives, and who would actually want to do it? So that's so we've been trying to work and find the ways to actually find like a first case to put it in, so I'll tell you in a minute about something specific. But I want to say that even though there are many challenges, there's clearly a great promise here. So we can make the law more efficient, just the legal system more efficient in the system, but we also, more than that, we can actually change legal thought and legal doctrine, and in the fact that we don't need to balance the truth, to compromise the truth-seeking process in order to accommodate the needs of the law enforcement of society. So we don't need to so this dilemma that I started with this first example, it's kind of a really dilemma from hell. On the one hand, if we disclose and we give, if we don't disclose and we don't give the defendant the right to inspect the process or the software or the evidence that incriminated them, then in some sense we lose everything, because we lose trust in the legal system, and what are we doing, right? So we just putting somebody in jail without having them giving the ability to dispute the evidence, right? So it's something we really cannot afford to do in a systematic way. On the other hand, if we always disclose, then the entire legal system, the prosecution process becomes way too costly and untenable, right? So again, we harm society, right? But the point is that we don't need to make this compromise from hell. We can have the cake and eat it too. So eat the cake and have it too. So and so this is something that the point that I wanted to make. And again, we allow for more trade-offs. And in fact, there's a bigger thing here. There's some co-design of law technology. How can we actually design legal system and algorithms hand in hand in a way to benefit both? So I'm going over time, but just to say one word, so we're, I talked at high level, but we did do. I want to tell you about one case that, again, this self-investigated tools case, we dove in more details and actually designed a legal system and a workflow that could potentially resolve this issue and actually fit in within the existing legal process, so at least in the U.S. So just to go into it very quickly, so we want to, we construct a legal setting for zero-knowledge proofs to help here. So what we do is the following. So the starting point. So there is a secret object X, which in our case is hidden software that law enforcement used in order to find incriminating evidence. So let's assume X is a text file. It doesn't matter. It can be many things. So what we're going to do. So the law enforcement, or this case, will actually write a check program C that checks different properties of X. So the law enforcement knows X, and it actually writes the set of properties that it thinks it should actually disclose about X to the defendant in order to convince the defendant that the program is okay, whatever set of checks. So this is the check program. This is the C, and now we write C in some language. It doesn't matter, and the statement will be I know X, for which C of X is true, but it's not just I know X. I want to make it specific to X. So we first be going to commit to this hidden value X, which is the program. And it's going to be this public information D, which we're going to disclose. And now the statement change to, there is an X such that for which the claims are true, and also the hash of X is this public information. So this pins down this X to something specific. And this is the statement. And now we can actually argue about what the statement is. This is a big argument, but maybe later, not today. But I'm happy to talk about it. But it don't take much time. So what's going to do? Then now the law enforcement, when in this process, when it submits the evidence, it actually also together with the evidence, it also gives this D, which is this hash or commitment of to this program X, and And also will give the C this check program that it divides, it's all about, says, okay, this is what we prove about the software. You don't trust us, but this is the software we designed, and these are the properties of the software. This is why we think this software is okay, right? And you can see the properties, you can read them, you can see if they're acceptable to you or not. And now the law enforcement will have to make sure that those properties are true will not compromise the secrecy of X. Also the defendant needs to make sure that that's enough for them. And if the defendant disagrees, then he says, no, you didn't prove that. Please show me this property. The same process that we have that exists today for existing software in the clear will actually happen ahead of time before you see the software, right? So until you decide, you agree on a set of claims that need to be asserted about the software, for everybody to be happy, and the judge can decide, which claims are okay or not. And once everybody agrees on this test, and this is again the legal human process, now one runs the zero knowledge proofs, and the court and the verifier and the defendant gets the bit that actually the software satisfies its claims or not, right? So so this is the suggested process, and of course there is a lot of details even here, but at least it's at the beginning. And the last point I wanted to make is that the very fact that we actually have laid out this process and that it exists and it is feasible already changes the legal landscape, even without it actually being used, right? Because one of the main points that the judge has to assert in this legal doctrine that determines whether law enforcement should or not be obliged to disclose its secret tools is whether law enforcement did everything feasible, reasonable in order to make everything that it can accessible to the defendant without disclosing things that it claims it doesn't want to disclose, right? And this is something that actually has been tried and acted upon in the past. When law enforcement does things which are egregiously not optimal, then the courts would punish law enforcement and say, no, this is something you cannot do. Your evidence is being dismissed. Just so that, because you didn't satisfy this best practices requirement, and you don't give the reasonable accommodations. So the very fact that these things exist, in some sense, forces law enforcement to take note of this and use it unless it has other ways to do it. So this is the kind of part of the legal theory part that argument that we're making. It remains to be seen if this is something that will have any teeth, but at least in principle, it should and it can. So this is the idea. So there's a lot more to do, of course. So those verification dilemmas are abundant, and we can make a big change in legal system. And the point is just to do it and to go step by step and more. So anyway, so this is essentially what I wanted to say. And I think that just maybe one last word, the zero knowledge, the legal system is one aspect, but I think the concept of zero knowledge is such a basic concept and such a natural concept in the end that in some sense it should be part of the discourse in every in conversation on the internet, right? So some sense I should have a button in my browser prove this in zero knowledge, right? So I want to say something to somebody, and I want to say, okay, I want to prove it without disclosing. I should have a way to do it in my browser. It should be so ubiquitous, and I think it's one of those things that once we have it, it will be hard to go back. maybe that we will not be understand how we actually, dealt without it. That's my thought or hope. Okay, that's it. I think I talked enough.
Thank you very much, Ran. So are there any questions either from in the room or from Zoom? If you are on Zoom, just unmute yourself.
I see the.
I see clapping hands.
People are.
Oh, I see also that you people are on the slim patches. So I guess so. One of the questions is whether how hard is it to explain these things to the lawyers, right? Because I mean, when you say like you can write C, I mean the check as a program and you can go back and forth, right? I mean, this requires. I mean, with the negotiation, for instance, on what should the program be, right? It's not just what the pseudocode should be, but it's also what exactly is this function implementing and how is it being implemented, and I mean all these things seem to be details seem to be very important to the system actually working as it's supposed to. So
you're right, and maybe I think maybe there. I mean, your question can be actually asked on two different levels. I don't know which one you meant. So maybe even three. So one level is maybe the conceptual level, how to explain the concept of general knowledge to lawyers and have them understand, the tool and what you can be done with it in principle. And that's maybe in some sense maybe it's the biggest challenge. So we wrote this paper. So the one of the two works that at least one of the two works that I mentioned at the beginning of the talk is a law review article that actually specifically wrote, together with the law professors, in law professor language, that our first task was to convince the three lawyers on the team of what this is and explain to them, and then have them write an explanation together with us and maybe convince others, and hopefully this will have some effect. And that's one level. So another level is about the zero knowledge itself. Because it's a whole big protocol, and how do we make sure the protocol actually does what it has to do? I think in some sense, of course, there is stuff to do there, but at least in the US, the legal system is actually receptive for that. The legal system accepts there are tools that work in some way that it's not clear how they work, but we just accept that they work, and we still can base legal doctrine on them. Sniffing dogs, right? We don't know how the sniffing dog works, but we know what they do. We think we know what they do, and we accept them. Is the legal evidence and other stuff like that. So I think this is something the legal system accepts. But there is a third aspect, which I think maybe this is the most harder to realize, but I think it's the most important one, is like how to write the predicates, and how, what exactly are those predicates I want to write on this program, that to make sure that on the one hand, it doesn't reveal too much information, on the other hand, it gives me the security I want. And this is really a big issue. We try to actually make stuff to this for a specific case in the second paper for a specific type of software. But this is really an issue. But I want to say something, it's not something we're going to resolve today, but just to say that the whatever we do is going to be millions of light years better than what is done today. So there's another case that I didn't talk about, you can read it in the paper, that similar setting, this hidden software, peer-to-peer network, CSAM, etc. But in that other case, when slightly different way, the defendant, instead of heading the prosecution head on, to facing head on, saying yes to close, not to close, the justice to decide. So okay, let's compromise. Let's have an expert witness that is going to get the software, and we're going to ask him questions, and they are going to answer the questions. And then, there is a whole, court record of how this went very badly. Because the questions are written in lawyer language, very, very high level. And it does not really give you any real confidence, computer science confidence on what the software, and give a lot of interpretation to the witness. And then, the witness said something, and then the defendant expert said, no, but you didn't do that, you didn't mean that, you didn't do that. At that point, the judge didn't care anymore and said, forget it. So just setting the language of, what it is you want to set about the process in a more technical term, this by itself already is a win. And like eliminate the human, the lawyer human in the loop for that. But there are lots more to say, but yeah, it's a very good question.
Thank you. Anyone from the Zoom link? Yeah, Adam.
Yeah. So in the business use case, it seems like it makes a lot of sense because the incentives sort of align, and it can maybe be slightly simpler data that's being proved on. But in the case of like law enforcement who has some kind of malicious software that they've been using to gather data, the model for that, like the circuit sounds incredibly complicated to prove correctness of a very large piece of software. I was wondering if there's been any feedback from law enforcement or judiciary on like how this would actually be implemented, or if they're willing to approach something like this.
Okay, so we don't have feedback from law enforcement, unfortunately. Actually, we tried to interact, and they, there was at least the people we were trying to interact with were not cooperative. But can try to, but there's why, etc. There's the whole political structure there. But this is a great question what you're asking, and the answer to that is actually something that Rebecca Wexler, which is the lawyer that worked with us on this case, the law professor who worked on this case, actually convinced me. I was asking exactly the same question. That's how we started from. Is that too daunting? Too complex? How do you even start? And what you said is that you don't need to solve everything. You just need to improve on the state of the art. Whatever you do that improves on the state of the art is already a big win. Even if you just prove some simple properties of the software, the very fact that there is a software and there is committed to and there is proof rate that already fixes a lot of the issues. Like this issue that we had before that, oops, we lost the software, it's not here anymore, it was a vendor, we didn't keep it. That's not going to happen because it's going to be committed and there's going to be a process on it, right? So, and in addition, also another thing that we did in this other paper, we actually stated a system. Look, there's this investigative tool that, of course, is very complex. But since the defendant had only very specific claims, is this something that did they really did the software? Did really got this all the pieces of the file from that particular computer, and did the software only send to the defendant legitimate LimeWire messages and not some other messages? This is something that is much easier to check. You don't have to check the entire logic of the program. You just have to check the log of the communication of the program, right? The program did not, and this could be simple text checking, right? So there are things you can do without, get a lot of bang for the buck without going through the whole thing of full-fledged software verification in zero knowledge. But yeah, so that's the 2-minute answer.
Thank you very much, Ran. So I think that's it for today, and I hope to see you back in Denmark soon.
Okay, thank you.